Members, we now move to the clauses debate. The question is clauses 1 and the debate is on clauses 1 and 2. Chris Hipkins.
Oh, thank you very much, Mr. Chairman, and I'm happy to take the first call on this.
As long as the member puts his collar down.
Oh, happy to dress myself properly. Oh, the jacket collar. Thank you for your sartorial advice, Mr. Chairman. Mr. Chairman, I'm very happy to take the first call on the summing up debate on what has been a significant discussion on issues related to housing, and we thank the government for the opportunity to do so. In the summing up debate, of course, we debate the title and the commencement of this bill, and I actually think that there is a different title for this bill. Perhaps we should call it the Hasher Bill, or in Nick Smith's case, the Hash Up Bill, because just about everything that the government does around housing is a hash up. And we have seen that today and yesterday and the day before, and in fact it's been ongoing for some time. But what is interesting about this particular debate on this particular series of amendments that the Labour Party has put forward is that while the government have no ideas of their own on how to deal with the housing crisis that New Zealand faces, they have voted against every single amendment and every single proposal put forward by the opposition that would actually deal with the substantial housing issues that New Zealand faces. But I want to turn in particular to the debate that we had on part 2 of this bill, because if anything, that demonstrates why this should be called the Hash Up or the Hasher Bill, because the government told us all the way through that debate and all the way through, right to the bitter end of that debate on the changes to property rights, that they weren't in fact changing anything. But let's be really clear. I want to know, because we have been researching this, and this is something that we would have raised during that part of the debate had it not been under urgency and we actually had the time to consider it properly. Some advice provided to the government, to the previous Labour government, when it was preparing a national policy statement, because the advice was very clear on offer-back provisions, in which it said that the existing legislation does not provide an exception where the disposal itself of the land is part of the public work, i.e. a housing development. This has significant implications for sustainable urban development projects which aim to create well-serviced parcels of land to sell to an end user, e.g. a developer, an owner-occupier, an institutional investor in affordable rental housing. In other words, the advice that the government gave this House all the way through the committee stages on part 2 of this bill was wrong, because it was inconsistent with the advice that previous governments had been given, and yet there had been no change to that part of the law. So how is it that a previous government could have been advised that there was no obligation, that the that the existing legislation did not provide exceptions when it came to the disposal of land as part of a public work, i.e. a housing development, and they were provided clear advice that that had implications for urban development and that the law would probably need to be changed, and yet the government today says that that wasn't the case. So I would like the Minister to take this opportunity in the closing stages of the debate to clarify exactly why the advice seems to be different now to what it was previously, although the law has not changed. And I'm looking forward to the Minister's contribution to that. Because if this is the position previously, and I want to go through it again, where it says this has significant implications for sustainable urban development projects which aim to create well-serviced parcels of land to sell to an end user, e.g. a developer, owner-occupier or institutional investor in affordable rental housing, if that was the case then, why is that not the case now? And I would like the Minister to answer that, because the government basically have pulled the wool over the House's eyes that this bill, by trying to say that this bill doesn't actually change anything and yet it is essential. Those two things are actually contradictory. Either it's essential and it changes something, or it doesn't change anything and therefore it's not essential. So which is it? Because it cannot be both. It cannot be so urgent that the government must push it through to avoid the potential that there will be litigation as a result of this loophole being identified, and yet say that actually there's no loophole. And yet the government are trying to run both arguments simultaneously, and they did all the way through part 2 of this debate, and yet we've now got clear evidence that the advice that they were giving the House is not true. Why did this bill not go to a select committee where that could have been properly teased out? The government could not answer that and did not make any attempt to answer that. I am asking, Mr Chairman,
Chris Hipkins.
I am asking for the government to actually now provide the explanations that it should have provided earlier on, because they haven't done so far. Perhaps in their summing up debate and in the minister's contributions, he might like to also explain why they voted against 8 concrete proposals that would have dealt with many of the issues that New Zealanders face when it comes to housing, and the government members chose, and the government party chose to vote against all of them, and I would very much like to hear more of that contribution. But the offer-back provisions, and I want to talk, because this was not an issue that we had the opportunity to canvass because the information was not available at the time. And so I want to quote again from the advice that the previous government received. Any land acquired for an urban development project or existing council or government-owned land within that project is likely to be sold. So even if it could be argued that a particular site should be compulsorily acquired for an urban renewal project, the offer-back obligation may still complicate matters when it comes time to sell the land. So again, I put that to the minister. If that was the position under the previous government, and the law in this area has not changed since then, why is the advice the minister is giving the House now so different to the advice that the government of the day back then received? This is what the whole issue and the whole, length of this debate has been driven by. A concern that the Parliament, under urgency, without any consultation with the public, is changing people's property rights, and they are not getting a chance to have a say on it. And that's actually that's a very significant thing for any Parliament to do under urgency, to change people's property rights. And not only to change them for now and for the future, but to change them retrospectively, which is what this legislation has done. So I hope that the minister will take this opportunity to give us a detailed explanation as to why a position that was long-standing, where the law has not changed, somehow has miraculously changed and the advice is now different. And I look forward to that contribution from the minister.
Mr Speaker.